Under Section 35(3)(k) of the South African Constitution, every accused person has the right to be tried in a language that the accused person understands, or, if that is not practicable, to have the proceedings interpreted in that language. This might sound like a basic procedural safeguard, but it has a profound historical and constitutional significance in South Africa. During apartheid, courts were overwhelmingly conducted in Afrikaans and English, the official languages of the state, which excluded and disempowered millions of Black South Africans who spoke Zulu, Xhosa, Sesotho, and other indigenous languages. Many accused people were convicted without fully understanding the proceedings against them. When the Democratic Constitution was adopted in 1996, this right wasn't merely about communication, it became a form of restorative justice. It recognized the deep power imbalances that language had played in the legal system and aimed to correct them. But the application of this right has raised complex legal and practical questions in post-apartheid South Africa. What if the court could conduct the trial in the accused home language, but chooses not to because it's inconvenient or costly? How do you ensure proper interpretation in rural areas where skilled legal interpreters are scarce? Is an imperfect interpretation a violation of the Constitution? In State versus Matamila in 1998, the court held that a failure to provide proper interpretation could render a trial unfair, and that courts must ensure that the accused fully understands the proceedings. The Constitutional Court has echoed this concern, recognizing that language rights in court are directly tied to dignity and access to justice. To this day, language barriers remain a serious issue in South African courts. Although the Constitution recognizes 11 official languages, in practice, English still dominates in written judgments, legal education, and court transcripts. There's a tension between constitutional ideals and practical implementation, especially in under-resourced magistrates' courts. Why this matters is because this right is about more than words. It's about ensuring that justice is not only done, but is seen to be done, and felt to be done by every South African in their own language. It reflects how deeply law, language, and power are entangled in South Africa's legal history and ongoing transformation.